Good evening and welcome to the September 2015 Richardson Law Office's Legal Hangout. I'm Steve Richardson, and we're going to talk about today a new law that came into effect beginning of last year, January 2014, called a conditional dismissal. Now, let me back up a minute and tell you that under New Jersey criminal law, the legislature understands that sometimes people get into trouble. They're good people. They're not criminals, career criminals. They made a mistake, and they get one shot at not ruining their lives. Okay, they get an escape plan, as it were. And it's a one-time thing, and it's usually for non-violent crimes, things like that. If you shoot somebody, something like that, it's just not going to work. And what these plans are called, they're called diversionary plans, and that's just it. You're diverted away from the more serious punishments that you could face for criminal charges as a result of one of these programs, diversionary programs. And there are different diversionary programs for different things. So New Jersey, we don't distinguish between, we don't call them felonies and misdemeanors. We call them indictable crimes, or first, second, third, fourth degree crimes, or the more minor disorderly persons offenses or petty disorderly persons offenses. But for our purposes today, we're just going to call them felonies and misdemeanors because those are terms that people are most familiar with. So if you're dealing with felonies, non-violent felonies that are handled at the county level by the county prosecutor and superior court judges, there's something called pretrial intervention, also known as PTI. And if you talk to a criminal attorney, they can tell you about what that can do for you depending upon the charges, and this is the first time you've gotten into trouble. For non-felony cases, misdemeanor drug possession cases that are handled in traffic court, municipal court here in New Jersey, we have something called a conditional dismissal. Again, you only get it once, but if you've been caught in possession of marijuana, something like that, not that serious an illegal drug, nothing like heroin or something like that, but marijuana or hashish, in a small amount that's obviously for personal use, then that is, there are some serious penalties for that misdemeanor in municipal court, but something called a conditional dismissal, conditional discharge, excuse me, comes into play that you can use to get out of trouble on that. And I'll leave a link in the notes for this episode to my website for an article on conditional dismissals. So pretrial intervention, conditional dismissal. But what if you're facing a non-drug related misdemeanor in traffic court? What do you do? Well, before 2014, you might be able to convince the prosecutor to drop it down to a municipal ordinance or something less severe. And for quite a while in my area, southern New Jersey municipal courts, a lot of times judges were pleading down, prosecutors were agreeing to plead down charges like shoplifting, petty theft, to a municipal ordinance. Well, that happened a little too often, and so it's really not offered anymore. But then, like I said, in January 2014, the conditional dismissal came into play for those misdemeanor charges. Now, understand that we're talking about three diversionary programs: pretrial intervention, conditional dismissal, and conditional discharge. Now, it's not one bite of the apple for each of them. It's one bite of the apple for a diversionary program. So, for example, if you got stopped by a police officer, and they found a small baggie of marijuana in your console there, or on the passenger seat, and you got charged with minor drug possession, and you completed a conditional discharge, and you're later caught for shoplifting, well, then you don't have the conditional dismissal available to you or any other diversionary program, because this isn't your first rodeo. This isn't the first time you've gotten in trouble. So a diversionary program is really not available to you anymore. So you have to be aware that it's a one-time thing. And if you use it, that's it. Don't get into trouble again. Okay? So what is conditional dismissal? Well, it applies to disorderly persons offenses and petty disorderly persons offenses, in essence, misdemeanors. How do you qualify for one? Well, you can't have any prior convictions for anything anywhere in the United States. So if you moved here to New Jersey from Ohio or Utah or Montana, but you had a conviction back there in Montana or that old state, well, then you don't get this program here. This really has to be, no matter what state you're in, your first time getting in trouble. So no convictions anywhere in the United States, first requirement. Second of all, no prior diversions. As I said before, you can't have gone through a diversionary program. You can't have taken advantage of pretrial intervention or conditional discharge or another a conditional dismissal. So you can't have one of those. It's only once. And finally, you do have to get court approval for that. The judge is going to look at the circumstances, recommendation of the prosecutor, things like that, and then decide whether you're going to be allowed into the program. I can tell you from experience, at least for the judges down here in the Gloucester County area, I don't expect that really to be a problem. Conditional discharges for drug offenses are fairly routinely granted. There is a check to make sure that you are eligible, but usually the judge and the prosecutor do not deny that to you. They want to move cases through the system. They understand why that program is there and what its function is, so that the one-time offender doesn't ruin their lives. So you have to do that. Now, how do you get one? Well, there's a cost of admission. In addition to whatever fines and penalties there may be, there is a $75 application fee. So you have to pay that. Secondly, you have to pay all costs, restitutions, and all other assessments that may be levied by the court. So, for example, if you were caught shoplifting, to use that charge, or some such thing as that, then if there's any kind of restitution, if the product you couldn't just hand it back, they weren't able to recover it, or it got damaged or destroyed, or there may be some restitution component to the shoplifting charge, for example, then you have to make sure that you do that. You have to comply with that. And the third thing is complete any other terms that the court may levy on you, in addition to monetary fines and costs. So you basically have to do everything the judge tells you to do. Now, what is often standard in shoplifting cases is the shop just said, we don't want to see you in here anymore. Okay, don't come back. Okay, don't come into the store. That's a forever thing, and you don't really face that sort of Damocles over your head that if you ever go back to the store, they can yank back the conditional dismissal per se, but comply with everything the judge tells you to do. All right. Now, the good news is that once you complete all of those requirements and do everything you're supposed to, then that charge is dismissed. So it was dismissed. You avoid a conviction for that offense, whether it's shoplifting or some other such thing. And as a result, you don't have that conviction on your record. You don't have a criminal record. Now, the arrest may still show up, and you have an arrest record because you were arrested for that. But you can, at some point, seek to have that arrest expunged from your record. Okay, there was an arrest, you completed the conditional dismissal, the charges were dismissed, there was no conviction, and then you come back later and sweep away the arrest. Now, more and more, as employers are asking you about this sort of thing, asking you, have you ever been convicted of a crime? And shoplifting is a crime, maybe a misdemeanor, but a disorderly person's offense, but it's still under our criminal code. So if the charges are dismissed and you're asked, have you ever been convicted of a crime? You can say no, because there was no conviction. The charges were dismissed. But if they ask you, have you ever been arrested? Well, yeah, you were arrested. You just were never convicted. But if you're able to get that arrest expunged, then you don't even have to say no, I've never been arrested, and that would be truthful. That would be the truth, because your record has been expunged and you have that available to you. So that these diversionary programs are a good thing. You with conditional discharge with drug programs, a lot of times you have to be a good boy or girl for a year. All right, that's a common thing that they put in, and they often have, because it's a drug-related charge, they may have random drug testing. So you, in addition to paying any other costs, et cetera, that are levied as a result of the charges, you would have to have a clean record, do not get into any trouble in that 1 year period of time, comply with the drug testing, pass the drug tests, so that the court can make sure that this isn't a problem. This isn't going to be an ongoing problem. So for a year, you're going to be monitored. So that's conditional dismissal on drug charges as opposed to conditional discharge. Conditional discharge on a drug charge as opposed to conditional dismissal on a shoplifting or other misdemeanor criminal offense. So it works a little differently, but the idea is fairly the same. You have to comply with certain requirements of the court in order for the program to complete and the charges to be dismissed. So if you or someone you know are facing misdemeanor charges here in New Jersey, talk to an attorney. See what can be done about getting a conditional dismissal. If this is the first brush with the law, you want that. And as tying into next month's topic, one of the things you have to be careful of, if you're a public employee, right, if you have a public job, then depending upon the charges, conviction of that charge could result in you either losing your job or losing your job and being barred from public employment for the rest of your life. You're basically barred from public employment, which can be very serious. So we're going to get into that next month, but you can see whereas if you are a public employee, maybe the charge, the misdemeanor that you're facing could qualify you for what's called forfeiture of your job. Then that's a critical thing to make sure you get is a conditional dismissal of the charges. Something to look into. So that's our program for this month in September 2015. We went a little shorter than we usually do. We've been running long the last couple months, so we're running short this month. Next month, we're instead of doing it on the 4th Thursday of the month as we normally do, we have 5 Thursdays in October, and we're going to do our October 2015 Hangout on October 29th, 2 days before Halloween. So it's 5 p.m. October 29th, and our topic is going to be public employment forfeiture. So if you have a public employment, you might be a teacher or a police officer, or you work for the town government or the state, or you have a federal job, these jobs can be subject to forfeiture, so you have to be careful. So what we're going to talk about next month is when forfeiture comes into play and how serious the forfeiture is. Is it just the loss of your current job, or is it the loss of any your current job and the possibility of any public employment in the future? So obviously an important topic to discuss. So that's it for this month. I'll see you next month on October 29th to talk about public employment forfeiture. So enjoy the beginning of fall and the cooling weather, and I'll see you just before Halloween.